Hey everyone, Harry here to talk about the Justice Department wasting no time in appealing the order of Judge Kacsmaryk saying that mifepristone, one of two drugs used in the most common abortion procedure in the United States, it has to be invalidated and taken off the shelves. So the department asked for two kinds of stays. Kacsmaryk said, I'll give you till next Friday to try to seek a stay. So they said, first, we'd like a temporary stay so you, Fifth Circuit, can consider our motion because you need time to decide should you put in a stay. And moreover, could you please do that by Thursday? Because if you don't give us the stay, we're going right to the Supreme Court, and we need that by Friday, which is when Judge Kacsmaryk says his order goes into operation. Then second, they asked for a longer stay, sort of on the merits of Kacsmaryk's order itself. They said this order is wrong and wrong-headed. We want to be able to litigate and prove that to you, Fifth Circuit. And while that's happening, we don't want the order to be in place. So here's a different motion for a stay. They're very strong as the Department of Justice in saying, look, this has been, we've had mifepristone operating safely for 20 plus years, and these plaintiffs who now say don't give a stay because if you have to act within hours or the nation will come falling down, never tried to step forward. So it was only after the Roe v. Wade was overruled and they went shopping for Judge Kacsmaryk that they even made this motion. And remember, this has nothing to do technically with Roe v. Wade and the overruling and the general movement. I think movement is a fair enough word in its wake to try to really minimize abortions throughout the country, not just in states whose legislatures are willing to adopt tough laws. If Roe v. Wade was a good law, what Kacsmaryk had to say was solid, it would still hold. That is, he's saying the FDA failed to go through its paces. It's this really, on the one hand, segmented little administrative law holding, and yet it seeks to basically take the most important abortion medication and procedure off the shelves. The DOJ also uses from the district court medical providers who say my patients are going to have permanent injury, which is something you need to show when you start talking about who should get a stay and who shouldn't. If you don't suspend Kacsmaryk's order while you decide, they point out a point I've made before that you could still take the second drug and prescribe it, and for the most part it would terminate pregnancies but lead to complications and bleeding and pain. It's sort of goes to show how kind of mean-spirited the order is, because it doesn't mean that women couldn't use this procedure. It just means they couldn't use it. It would result in much more complications and pain and the like. So they come in and say, look, they're going to suffer irreparable harm, will these women, and that's what you need to win a stay. You need to show people are really going to get hurt if this stays in place while you upper court decide, and you're probably going to decide for us based on the law. And that's the other big part of the motion that they filed so quickly and signaled they're ready to take it to the Supreme Court. In the meantime, back in Washington state, you recall, a judge entered an exact opposite order saying FDA do nothing of the sort. And there the DOJ has entered a order or filing that says, can you clarify exactly what you mean, how this is supposed to operate with the Kacsmaryk order that it appears to directly contradict, etc. But it seems to me that this issue is going to be going to the Supreme Court either quickly or in due course. The quickly part would be if for any reason the Fifth Circuit doesn't enter a stay, and maybe the Washington does enter or reanimate its own stay. Now we have these, complete irreconcilable orders, and that's the kind of thing that the court will need to decide quickly. The alternative is the Fifth Circuit does enter a stay and takes its time to decide Kacsmaryk's motion on the merits. Is he right that the FDA didn't do this and should have done that? And even though there's a 20-year record of safety, they didn't do the things that they're supposed to do in order to ensure things are safe and the like, and therefore we strike it all down. It's kind of a whole Alice in Wonderland situation, legal situation, because we've seen the future. It's, it's 20 years where everything is safe. And the DOJ also points out this is sending it in the mail. The DOJ has made clear is legal. And so this affects every state in the union. The DOJ has said that can't stop. That would be a discrimination against federal law. Now, that means if individuals in, say, Texas or Tennessee, if law enforcement wants to track it and storm down the doors for women suspected of giving abortions, well, they may be permitted under their own draconian laws, but the right of women to get these medications has not been endowed until last Friday. So a very solid motion by the Department of Justice saying there's irreparable harm to our patients, and plaintiffs haven't stated any harm at all, much less irreparable harm, and we're good on the merits, so you need to enter the stay. And they might. The Fifth Circuit might, even if they want to go the other way at the end of the day. If they don't, we scramble up to the Supreme Court and they decide it sooner rather than later. But I think unless the Fifth Circuit takes it alone and does a really definitive opinion completely reversing Kacsmaryk, then I think we see this in the Supreme Court anyway. Okay, there you have it. The mischief that one staunchly anti-abortion federal judge can make, now winding its way through the system's prescribed channels, hopefully to a remedy. We'll follow it closely for sure. So until then, talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.